We had major breaking news this week with the United States Court of Appeals for the Third Circuit out of Delaware, Pennsylvania, and, of course, New Jersey issued a major Second Amendment ruling saying that 18 to 20-year-olds are part of the people and have a right to keep and bear arms, including to carry guns in public, like all other American adults. Now, this was a 2-1 decision. The dissenting judge, Judge Luis Restrepo, wrote a powerful dissent. Not really, but he did write a dissent. I want to take apart the 3 major arguments that he made because you're probably going to hear this argument again next year in the U.S. Supreme Court when one of these 18 to 20-year-old cases gets to the Supreme Court, and it's mission critical we win these cases because, as you know, every brick that we win, every case that we win is another precedent that protects our right to keep and bear arms, and we need a lot of them. Stay tuned. Let's break down the dissent of Judge Luis Restrepo in the LARA case in the Third Circuit. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and proud to say a top 5 finalist in 2 separate categories for the 2024 Gundies Awards, top male influencer in the Second Amendment space, and also top voices of the Second Amendment. Happy and proud to be in both categories as a finalist. All right, folks, as you know, we had a major win this week. United States Court of Appeals for the Third Circuit covers the states of Pennsylvania, New Jersey, and Delaware. In a case called LARA, issued a decision that says that 18 to 20-year-olds cannot be denied their full Second Amendment rights, and that Pennsylvania had laws, a combination of laws that essentially violated their rights because it prevented 18 to 20-year-olds from being able to carry guns in public, which all other Americans are allowed to do under the Second Amendment. This is a major win. But this decision was a 2-1 decision in favor of the Second Amendment. So some of you have asked, what exactly did the dissenting judge, an Obama appointee named Luis Restrepo, what did Judge Restrepo have to say about why he thinks that 18 to 20-year-olds do not have a right to keep and bear arms under the Second Amendment? So I want to break down his 3 main arguments and explain why they're wrong and why the majority correctly rejected them. To begin with, we all understand that under the Bruen methodology, which again is really the Heller-Bruen methodology, because all Bruen did is took the Heller case and elaborated a little bit to make sure that lower courts didn't keep screwing it up. So they really took the Heller case, and then they basically in Bruen did a paint-by-numbers job to say, hey, you inferior courts under Article 3, that's what they're called, inferior courts, to the U.S. Supreme Court, please follow this paint-by-number approach to interpreting the Second Amendment and apply it in future cases, and that's what you're supposed to do. And as you know, the way that works is you start with the text of the Second Amendment as defined by the U.S. Supreme Court in the Heller case. In Heller, the Supreme Court looked at what the various words meant, the words that are found in the Second Amendment, who are the people, what is an arm, what does it mean to bear, what does it mean to keep, and they define these terms using 18th century dictionaries put forth by lexicographers. A lexicographer is someone that creates dictionaries, put forth by various 18th century lexicographers and founding era lexicographers such as Noah Webster, who was an American who did an American English dictionary of American English, and Samuel Johnson, who was a British lexicographer who did English. And they all agreed basically on the concept of what these terms meant. Now, what's interesting is in this case about whether or not 18 to 20-year-olds have a right to keep and bear arms, it starts off textually with who are the people. And as you know, under Bruen, once someone falls within the definition of the people and their right to keep and bear arms is infringed, which simply means to hinder or to really harass or to destroy, then that gun control law that is infringing upon or hindering the right of the people to keep and bear arms shall not be infringed. Once that's occurring, guess what? The burden shifts to the government to justify that existence of the modern day gun control law, and the only way they can do it is by looking at actual laws on the books, and this is going to be important for the LARA case. Actual laws on the books in the 18th century that actually restricted gun rights in some particular way, which they view as demonstrating that the Founding Fathers would have been okay with some gun-related restrictions, such as you can't use a gun to commit murder. That's not a Second Amendment right to commit murder with a gun, for example. Okay. Now, of course, the first step is you start with the text of the Second Amendment. And this is where Judge Restrepo's dissent immediately goes off the rails. Because remember how I explained to you that what the anti-gun movement wants to do in the United States is they want to elevate all fights about the meaning of the Second Amendment to the textual level. And that's because, remember, you start at the text first. Once the text of the Second Amendment is implicated by a modern-day gun control law, the burden shifts. You hear what I just said? This is key. The burden shifts to the government, and the government bears the burden to come forth with powerful evidence, compelling evidence, that the law is constitutional using historical evidence. And if they're not able to come forth with that evidence for any reason whatsoever, including but not limited to, there is no evidence of gun control laws at the time of the founding that are analogous to what they want to enforce today, for example, then the government loses. So as a consequence of this, it's extremely important to understand this. As a consequence of this, and we talked about this on the channel many times before, the government has every incentive to elevate Second Amendment fights to the textual level, because at the textual level, the burden is arguably more on the plaintiffs or the Second Amendment community to show that the text has been implicated. So what the anti-gun movement wants to do is to elevate every conceivable fight about Second Amendment to the textual level. Why? Because at the textual level, the burden has not yet shifted to the government. And the government doesn't want the burden to shift to them, because once the burden shifts from the text to the government to come forth with historical analog laws, they are toasty-moasty most of the time, because they simply are not able to do it, because the founding fathers simply did not believe in gun control. That's why they adopted the Second Amendment in 1791, and that's why when there were areas that were really at risk of an attack, like an Indian attack, the answer of the founding fathers was not to put a no tomahawk sign on the schoolhouse wall or to put a no tomahawk sign on a church. They did the reverse, which was to encourage, if not mandate, that people were to bring arms with them to, for example, church on Sunday in anticipation of a potential attack from the Native Americans, as an example. So with all that said, the first mistake that Judge Restrepo makes here is to embrace what the gun control lobby wants, which is to elevate the question of who are the people to the textual level. So Judge Restrepo looks at the text of the Second Amendment. He says, well, the right of the people to keep and bear arms shall not be infringed. Then he says, well, who are the people? Here's the key. The Supreme Court has already defined who are the people. In Heller, the Supreme Court discusses extensively that the people refer to all individual Americans. This is specifically what the Supreme Court quotes. In Heller, they quote a case called United States versus Verdugo, which is a 1990 Supreme Court case. This is what Justice Scalia writes in Heller. He writes, quote, "The people seems to have been a term of art employed in select parts of the Constitution. Its uses suggest that the people protected by the Fourth Amendment and by the First and Second Amendments, and to whom rights and powers are reserved in the Ninth and Tenth Amendments, refers to a class of persons who are part of a national community or who otherwise have developed sufficient connection with this country to be considered part of that community." Period, close quote. So as you see there, textually in the Constitution, the people refers to, at a minimum, all Americans, and maybe even green card holders and beyond that. But we don't need to get into that, because that's not the issue in LARA. They were American citizens in LARA, so we don't have to worry about if it goes beyond that. The bottom line is, if you are an American citizen, at a textual level, you are part of the people. The right of the people to keep and bear arms shall not be infringed. As a consequence, at the textual level, undeniably, the plaintiffs in the LARA case were part of the people. And once that's the case, and then it turns out that they were restricted from the ability to carry guns in public in Pennsylvania, which obviously infringes on the right of the people to keep and bear arms, as a matter of text, guess what? The burden shifts to the government. Now, what the Judge Restrepo tried to play this game is, again, he tried to argue that there's all this historical, see the game? There's all this historical information that says that 18 to 20-year-olds were not allowed to have guns. And then he says that's part of the text. You see? Oh, see the little game? Okay, he doesn't say that the people in the text of the Second Amendment is all Americans. Instead, he tries to elevate the historical discussion into the textual level. Why? Because at that point, the burden still remains with the Second Amendment plaintiffs to show that that the text is satisfied. So what should have occurred, and what the majority did, thank God, is they said no, the text of the people is defined by the Supreme Court. Obviously, these plaintiffs are part of the people, and therefore the burden shifts to the government. Now, the government bears the burden to overcome the presumption that the law is unconstitutional. And once that burden shifts to the government, again, the government is generally speaking toasty-mosty, because most of these modern gun control laws are unconstitutional and would never be acceptable in the 18th century. Now, the second major mistake that Judge Restrepo makes or talks about in his dissent is he says that at the founding, he quotes, remember my rule, airy-fairy history is bad. That is not allowed. The Supreme Court in Bruen made it very clear that the only laws on the books have to be long-standing actual laws on the book in the 18th century that relate to guns and are enforceable. It cannot be airy-fairy history. This is important to understand because the anti-gun movement wants to trot out at every turn, some Ivy League professor, maybe Claudine Gay or Claudine Gay's colleagues or the like. You know exactly what I'm saying here. Trot them out and have them give some interpretation of American history right out of maybe the 1619 Project. Who knows? But whatever they're going to come up with, I can promise you, it will be some explanation that Abraham Lincoln is gay, which is out there, by the way. That's some history out there, believe it or not. Or some analogous kind of argument about, oh no, the Founding Fathers really believed in gun control, even though they enacted the Second Amendment. They really think that no one's allowed to have a gun. And let me give you like 5 Ivy League professors that will say exactly that. No, nada, not allowed. Because the Supreme Court nipped this in the bud because they're kind of smart. And they specifically says that the burden on the government is not to come forth with airy-fairy history, making stuff up or inventing stuff or telling stories. None of that is allowed. The only thing that's allowed is the government has to come forth and say, here's an actual law on the book. It could be a state constitutional law, it could be a federal constitutional law, it could be common law possibly, it could be a state statute, whatever it is, there has to be actual laws on the book. There has to be many of these things that have to be somewhat ubiquitous. It can't be an isolated outlier example. That doesn't count. It's got to be well established, well representative, no type 2 logical errors if you're a philosopher. None of that stuff is a go, and that is basically, with that said, now we turn to look at what Judge Restrepo said in his dissent. He goes on to basically say that there's history out there, and everyone acknowledges as a conceptual matter that the age of 21 is when you became the age of the majority. That's when you were fully a full American citizen. That was the age of the majority. And as a consequence, that is a sufficient historical analog law to justify 18 to 20-year-olds not being able to have guns. But the problem there is that a very generalized concept of the age of majority, which maybe involves families, property rights, inheritance, it doesn't matter, all these other things other than guns, right? That may conceptually be true, but the Supreme Court says, no, we want to see gun control related laws on the book in the 18th century. That's the only thing we will consider even as a possibility of restricting the Second Amendment rights in terms of the historical matter. And then here's the key. Judge Restrepo simply can't get over the fact that the specific gun-related laws at the time of the founding in the 18th century spoke specifically to that 18 to 20-year-olds were required to bring their own firearms, their own cartridges, their own ammunition with them to militia musters. Hear what I just said? The laws on the books at the time of the founding that relate to guns and firearms and ammunition and the things that are analogous to a modern-day gun control law and not airy-fairy history, those, guess what, say that 18 to 20-year-olds have not just the right to get guns, but have to bring their own guns to militia musters under the Federal Militia Act of 1792. Now, how is it possible that Congress in 1792, 1 year after the adoption of the Second Amendment and the Bill of Rights in 1791, how would it be possible to even write that law or think about that law if 18, 19, and 20-year-old Americans were not able to procure guns privately in the first place? Because, again, these guns they're supposed to bring to the militia musters were their own private guns that they themselves own. And how does one usually acquire guns back in the 18th century and today? Oh, I don't know. Maybe you have to go buy the gun. It might be a little hard to buy guns and all this stuff. If you were banned from having guns or banned from buying guns when you're 18, 19, and 20, that would be a little tricky. But no one thought that was the case because, again, not only were 18, 19, and 20-year-olds allowed to have guns, it was part of their right to have guns, and they were part of the people, as in the right of the people to keep their arms, but they were actually required to bring those privately acquired guns with them to militia musters. So obviously, the history shows that regardless regardless of what you want to debate about the age of majority, the reality is when it comes to gun rights, 18 is when it was triggered, undeniably. Of course, the Militia Act of 1792 is the best evidence of this as I see it. And the third thing that Judge Restrepo gets wrong in his dissent in the LARA case dealing with 18 to 20-year-olds and whether or not they have a right to carry guns in public, he simply discards the militia laws because he says the minimum age standards vary by state, and you cannot infer a right under the Second Amendment from a duty to engage in militia services. Now, this is key to understand. Judge Restrepo's dissent in LARA is wrong for yet another reason, which is that the arguments he raises about minimum age standards for militias varied by state is not accurate historically because first, in 1791, which is the year that the Bill of Rights was adopted, at that point, the minimum age requirements were all at least 18. So that's why Congress in the Militia Act of 1792 said that 18 to 45-year-old white males, able-bodied, were in the militia is because that was where you had your right. That was where you were in the militia at 18 in 1791. Now, it is true, you will see stories in their own discussions about some militias having 15, 16, 17-year-old kids in the militia during the Revolutionary War or before 1791. That did occur. But really, 18 years of age is where all the laws eventually coalesced around in 1791 and thereafter. So that really is the right answer. And there's a practical consideration here. I know we're not supposed to get into practical considerations, but I'm going to give it to you anyway in case some of you think it's a good idea to argue that 16 and 17-year-olds have the right to keep and bear arms. The reality is we have to be sensitive to the fact that we're dealing with federal courts here and judges. So I suspect it might be a bit of a lift to get judges to think that 16 and 17-year-olds have a right to keep and bear arms in the modern world. Again, I'm just giving you kind of a practical consideration here. I'm not saying it's right or wrong constitutionally, but it's clearly the case that 18 and 19 and 20-year-olds have a right to keep and bear arms. Anything earlier than that, probably a heavy lift. Again, nothing wrong with people who have kids that if they're under the age of 18, parents buy them guns and so on. But as to whether or not they get the right historically under the Second Amendment, I think 18 is about as far down as you're going to legally be able to get with the modern day court system. That's just my practical reality. And it's the right constitutional answer, frankly, as I see it, because again, 18 and 1791 is where all the militia laws really coalesced around the age of 18. So I think that is ultimately the platonic right answer in addition to a practically the correct answer as well. And the last point I want to make about this militia argument that Judge Restrepo kind of rejects is this. He tries to say that the Militia Act is a duty. It's an obligation and not a right. But he's conflating two things, right? You have the right of the people to keep and bear arms, which is a right. Now, a well-regulated militia being necessary for the security of a free state was the prefatory clause, like one of the reasons why the right of the people to keep and bear arms was written into the Constitution. Yes, but the way it works is this, that in order to have a well-regulated militia, there has to be a necessary condition, right? And what is that? The most basic necessary condition of a well-regulated militia is you have to have humans with guns that can go into or work or associate with the well-regulated militia. And that's why the Bill of Rights and the Second Amendment works together. The right of the people to keep and bear arms, which is a pre-existing right that goes all the way back at a minimum to the English Declaration of Rights of 1689, the right of the people to keep and bear arms, which is a pre-existing right, shall not be infringed, right? That sentence is written in a way that it's a pre-existing right. It doesn't create anything. It's recognized and exists, and that existing right, that pre-existing right, shall not be infringed. Now, you combine it with the prefatory clause of a well-regulated militia being necessary for the security of a free state. Again, what Judge Restrepo is saying is you can't talk about militia laws because it's not talking about a right. It's talking about a duty or an obligation. But he's ignoring the fact that they work together. You have armed citizens guaranteed to exist because of the right of the people to keep and bear arms shall not be infringed. So you're guaranteed an armed citizenry. You've got guns, I've got guns, he's got guns, she's got guns, everyone's got guns. And if the militia is necessary, if the militia is called up, or whatever you want to say, or we have to form our own, whatever it happens to be, the reality is you have to have an armed citizenry first in order to have a well-regulated militia. And what Judge Restrepo does here is he conflates the two, and he should not do that because, again, one is a necessary condition for the prefatory clause of the well-regulated militia, and again, Judge Restrepo does not, in his dissent, make this clear distinction as well he should have. But the good news is the majority got it right, 2-1, major win for the Second Amendment and 18 to 20-year-olds young adults. I think this is going to be a major building block for future Second Amendment wins because the U.S. Court of Appeals for the Third Circuit is super important. And no, I don't think this will be be en banc. And no, I don't think this particular case will go to the Supreme Court because of some procedural issues I will not bore you with. But the bottom line is, major win, this lower case. It's going to stand. I don't see any problems with it getting knocked out anytime soon or en banc or anything like that. We might see if we were in a different circuit like the Court of Appeals for the Ninth Circuit in California and so on. Okay? All right, folks. Hope you learned a little bit something here today. If you haven't subscribed, please do so. A lot of people are getting knocked off the subscription list, so please subscribe and resubscribe if you're not sure. And make sure you follow me on X at 4 Boxes Diner. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.